Ministry of Law and Justice Legislative Department. New Delhi, the 9th of August 2021, Shravan 18, 1943 Sacker. The following Act of Parliament received the assent of the President on the 7th of August 2021 and is hereby published for general information. C.E. The Juvenile Justice, Care and Protection of Children. Amendment ACT, 2021 No. 23 of 2021. The 7th of August 2021. An Act to amend the Juvenile Justice, Care and Protection of Children Act, 2015. Be it enacted by Parliament in the 72nd year of the Republic of India as follows. 1. This Act may be called the Juvenile Justice, Care and Protection of Children Amendment Act, 2021. 2. It shall come into force on such date as the central government may, by notification in the Official Gazette, appoint. 2. In Section 2 of the Juvenile Justice, Care and Protection of Children Act, 2015, hereinafter referred to as the Principal Act, I, Clause 4, shall be omitted. Amendment of Section 2. Short Title and Commencement. 2 of 2016. E. In Clause 14. A. In Sub-Clause E. After the words, contravention of, the words, the provisions of this Act or, shall be inserted. B. For Sub-Clause B. The following Sub-Clause shall be substituted, namely, we who does not have parents and no one is willing to take care of and protect or who is abandoned or surrendered. C. In Sub-Clause X. For the words, is likely to be, the words, has been or is being or is likely to be, shall be substituted. E. In Clause 17. For the words, children's home, the words, child care institution, shall be substituted. IV. In Clause 26. For the words, which is the focal point, the words, which shall function under the supervision of the district magistrate, shall be substituted. V. After Clause 26, the following clause shall be inserted, namely, 26A. District magistrate includes additional district magistrate of the district. V. In Clause 46, the words, the person in charge of which is willing, shall be omitted. V. For Clause 54, the following clause shall be substituted, namely, 54. Serious offences, includes the offences for which the punishment under the Indian Penal Code or any other law for the time being in force is, a minimum imprisonment for a term more than 3 years and not exceeding 7 years. Or B. Maximum imprisonment for a term more than 7 years but no minimum imprisonment or minimum imprisonment of less than 7 years is provided. 3. In Section 3 of the Principal Act, for the words, the board, and the words, the board, the committee, or, shall be substituted. 4. In Section 4 of the Principal Act, in subsection 7 in Clause E, for the words, less than, the word, minimum, shall be substituted. 5. In Section 8 of the Principal Act, in subsection 3 in Clause M, for the words, of such a child to the observation home, the words, that child to an observation home or place of safety, as the case may be, shall be substituted. 6. In Section 12 of the Principal Act, in subsection 2 after the words, observation home, the words, or a place of safety, as the case may be, shall be inserted. 7. In Section 16 of the Principal Act, after subsection 3, the following subsection shall be inserted, namely, 4. The district magistrate may, as and when required, in the best interest of a child, call for any information from all the stakeholders including the board and the committee. 8. In Section 18 of the Principal Act, in subsection 1 after the words, heinous offense, the words and figures, or a child above the age of 16 years has committed a heinous offense and the board has, after preliminary assessment under Section 15, disposed of the matter, shall be inserted. Amendment of Section 3. 45 of 1860. Amendment of Section 4. Amendment of Section 8. Amendment of Section 12. Amendment of Section 16. Amendment of Section 18. SEC. 1. The Gazette of India Extraordinary 3. 9. In Section 27 of the Principal Act, I, for subsection 4, the following subsections shall be substituted, namely, 4. No person shall be appointed as a member of the committee unless he has a degree in child psychology or psychiatry or law or social work or sociology or human health or education or human development or special education for differently abled children and has been actively involved in health, education or welfare activities pertaining to children for 7 years, or as a practicing professional with a degree in child psychology or psychiatry or law or social work or sociology or human health or education or human development or special education for differently abled children. 4.8 No person shall be eligible for selection as a member of the committee if he I. has any past record of violation of human rights or child rights, e. has been convicted of an offense involving moral turpitude, and such conviction has not been reversed or has not been granted full pardon in respect of such offense, e. has been removed or dismissed from service of the Government of India or state government or an undertaking or corporation owned or controlled by the Government of India or state government, IV. has ever indulged in child abuse or employment of child labor or moral act or any other violation of human rights or moral acts, or V. is part of management of a child care institution in a district. E. in subsection 7 in clause E, for the words less than, the word minimum shall be substituted. E. for subsection 8 the following subsection shall be substituted, namely, 8 the committee shall submit a report to the district magistrate in such form as may be prescribed, and the district magistrate shall conduct a quarterly review of the functioning of the committee. IV. for subsection 10 the following subsection shall be substituted, namely, 10th the district magistrate shall be the grievance redressal authority to entertain any grievance arising out of the functioning of the committee and the affected child or anyone connected with the child, as the case may be, may file a complaint before the district magistrate, who shall take cognizance of the action of the committee and, after giving the parties an opportunity of being heard, pass appropriate order. 10. In section 32 of the Principal Act, for subsection 2, the following subsection shall be substituted, namely, 2. The information regarding a child referred to in subsection 1 shall be uploaded by the committee of the district child protection unit or the child care institution, as the case may be, on a portal as may be specified by the central government in this behalf. 11. In section 37 of the Principal Act, in subsection 1, the words submitted by child welfare officer shall be omitted. 12. In section 38 of the Principal Act, in subsection 5, after the words shall inform, the words the district magistrate shall be inserted. Amendment of section 32. Amendment of section 37. Amendment of section 38. Amendment of section 27. 4. The Gazette of India Extraordinary Part 2. 13. In section 40 of the Principal Act, after subsection 3, the following subsection shall be inserted, namely, 4. The committee shall submit a quarterly report regarding restored, dead and runaway children to the state government and the district magistrate in such form as may be prescribed. 14. In section 41 of the Principal Act, I. in subsection 1, the words, within a period of 6 months from the date of commencement of this act, shall be omitted. E. in subsection 2, for the words, shall determine, the words, shall, after considering the recommendations of the district magistrate, determine, shall be substituted. 15. In section 54 of the Principal Act, I. in subsection 2, for the words, district child protection units a state government, as the case may be, the words district magistrate shall be substituted. E. in subsection 3, for the words district child protection unit or the state government, the words district magistrate shall be substituted. 16. In section 55 of the Principal Act, in subsection 1, after the words state government, the words or district magistrate shall be inserted. 17. In section 56 of the Principal Act, in subsection 5, for the word court, the words district magistrate shall be substituted. 18. In section 58 of the Principal Act, I. in subsection 3, for the words in the court, the words before the district magistrate shall be substituted. E. in subsection 4, for the words court order, the words order passed by the district magistrate shall be substituted. 19. In section 59 of the Principal Act, I. in subsection 7, for the words in the court, the words before the district magistrate shall be substituted. E. in subsection 8, for the words court order, the words order passed by the district magistrate shall be substituted. 20. In section 60 of the Principal Act, in subsection 1, for the word court, the words district magistrate shall be substituted. 21. In Section 61 of the Principal Act, I for the marginal heading, the following marginal heading shall be substituted, namely, Procedure for Disposal of Adoption Proceedings. E. In subsection 1, for the word court, the words district magistrate shall be substituted. E. In subsection 2, for the word court, the words district magistrate shall be substituted. 22. In Section 63 of the Principal Act, for the word court, the words district magistrate shall be substituted. Amendment of Section 40. Amendment of Section 41. Amendment of Section 54. Amendment of Section 55. Amendment of Section 56. Amendment of Section 58. Amendment of Section 59. Amendment of Section 60. Amendment of Section 61. Amendment of Section 63. SEC. 1. The Gazette of India Extraordinary 5. 23. In Section 64 of the Principal Act, for the words concerned courts, the words district magistrate shall be substituted. 24. In Section 65 of the Principal Act, in subsection 4, for the word court, the words district magistrate shall be substituted. 25. In Section 74 of the Principal Act, in subsection 2, for the words in cases where the case, the words in the pending case or in the case which shall be substituted. 26. For Section 86 of the Principal Act, the following section shall be substituted, namely, 86. 1. Where an offence under this Act is punishable with imprisonment for a term of more than 7 years, then, such offence shall be cognizable and non-bailable. 2. Where an offence under this Act is punishable with imprisonment for a term of 3 years and above, but not more than 7 years, then, such offence shall be non-cognizable and non-bailable. 3. Where an offence under this Act is punishable with imprisonment for less than 3 years or with fine only, then, such offence shall be non-cognizable and bailable. 4. Notwithstanding anything contained in the Code of Criminal Procedure, 1973 or the Commission for Protection of Child Rights Act, 2005 or the Protection of Children from Sexual Offences Act, 2012, offences under this Act shall be triable by the Children's Court. 27. In Section 87 of the Principal Act, for the explanation, the following explanation shall be substituted, namely, explanation. For the purposes of this section, the expression abetment shall have the same meaning as assigned to it in Section 107 of the Indian Penal Code. 28. In Section 101 of the Principal Act, I for subsection 3, the following subsection shall be substituted, namely, 3. No appeal shall lie from any order of acquittal made by the board in respect of a child alleged to have committed an offence other than the heinous offence by a child who has completed or is above the age of 16 years. E. After subsection 5, the following subsections shall be inserted, namely, 6. Any person aggrieved by an adoption order passed by the district magistrate may, within a period of 30 days from the date of such order passed by the district magistrate, file an appeal before the divisional commissioner. 7. Every appeal filed under subsection 6 shall be decided as expeditiously as possible and an endeavor shall be made to dispose it within a period of 4 weeks from the date of filing of the appeal, provided that where there is no divisional commissioner, the state government or union territory administration, as the case may be, may, by notification, empower an officer equivalent to the rank of the divisional commissioner to decide the appeal. 29. In Section 110 of the Principal Act, in subsection 2, A. After clause T, the following clause shall be inserted, namely, ZIVA, the form of report submitted to the district magistrate under subsection 8 of Section 27. Amendment of Section 64. Amendment of Section 65. Amendment of Section 74. Substitution of Section 86. Classification of offences and designated court. 2 of 1974. 4 of 2006. 32 of 2012. Amendment of Section 87. 45 of 1860. Amendment of Section 110. Amendment of Section 101. B. After clause XXII, the following clause shall be inserted, namely, ECIA, the form of quarterly report regarding restored, dead and runaway children under subsection 4 of Section 40. Anup Kumar MENDIRATTA, Secretary to the Gov. of India. MGIPMRND 658GIS3, the 9th of August 2021. Uploaded by the Manager, Government of India Press, Minto Road, New Delhi 110002 and published by the Controller of Publications, Delhi 110,054. 6. The Gazette of India Extraordinary Part 2, Sec. 1.